Today we are talking about the differences between invention and innovation within patent application tests. First off, invention is the idea of creating or introducing a new product. We think about things like the light bulb, patented in 1879, the automobile, patented in 1879, the aeroplane, patented in 1879, and the telephone, patented in 1876. When we think about innovation, it becomes a little harder to define. We often think about things like technology, such as iTunes, iPods, and Facebook. But innovation occurs in every industry, for example, pharmaceutical and medical advancements. Standard application tests relate to inventions. To be granted a standard patent, the Commissioner must be satisfied on the balance of probabilities that the application is manner of manufacture, when compared with what existed before, is novel, involves an inventive step, is useful, and was not secretly used before the priority date. To obtain a standard patent, an invention needs to be inventive or not obvious to another person with similar skills in the area. To determine inventiveness, we can question, would a non-inventive person who is experienced and knowledgeable in the area of technology to which the invention relates, when faced with the same problem, have taken as a matter of routine whatever steps there were that led to the invention? The full court in Lockwood's case, concerning key controlled latches and their patents, developed a 5-step process to determine inventiveness. To identify what stage is inventive, determine the relevant art with which the invention is concerned, determine the general common knowledge on the relevant field at priority date, identify differences between the claimed invention and the state of the art, and determine if the differences involve some degree of inventiveness or are simply a plain difference. Innovation application tests were introduced to legislation in 2001 and were designed to stimulate innovation in Australia. To apply for an innovation patent, the Commissioner must be satisfied that the invention is a manner of manufacture, when compared with the prior art base is novel, involves an innovative step, is useful and not secretly used before. So what is the innovative step? As stated by IP Australia, an innovative step exists when the invention is different from what is known before and the difference makes a substantial contribution to the working of the invention. The Jura case concerning patents for design of roadside posts which supported roadside signage, developed a 2-step process to determine whether the innovative step has been satisfied. 1. To compare the invention as claimed in each claim with the prior art base and determine the difference or differences. And 2. To look at those differences through the eyes of a person skilled in the relevant art area as it existed in Australia, and then ask whether the invention as claimed only varies in ways that make no substantial contribution to the working of the invention. Substantial means real or of substance. In summary, invention relates to new, inventive designs, a quite high threshold to determine, compared with innovative designs, where only a significant contribution to the existing design is required. However, both provide for the same remedies. Thank you for watching. I hope that you've gained some knowledge from this tutorial.